Welcome to the deep dive. Today, we're plunging into something absolutely fundamental to making deals, whether it's, buying a coffee or a multi-million pound company.
Yeah.
The agreement.
Yeah, specifically, we're breaking down the bedrock principles of offer and acceptance in contract law.
It's the handshake, isn't it? The meeting of minds where potential promises start to solidify into legally binding commitments.
Getting this right is not just important, it's critical.
And this deep dive is built directly on educational materials generously made available by the University of London. We are incredibly grateful they share these resources, letting us go into this kind of detail.
Absolutely. So just to be clear, this session is for educational purposes only.
Right. It's designed to help you, especially those of you maybe grappling with these concepts for studies or exams, gain a really thorough understanding and feel prepared.
That's the mission today. Guide you through the complexities, the key cases, the tricky exceptions, so you can confidently identify offer and acceptance in, say, problem questions.
And this deep dive is brought to you by Sinorbit Academy, Sri Lanka. A huge thank you to them for supporting these educational explorations.
And to everyone studying this, particularly if you have an exam coming up, seriously, good luck.
You are putting in the work, and we're here to help you nail it.
Okay, so forming a binding contract. It's not just about shaking hands. English law needs several key ingredients, all present.
Right. Today, we're focusing just on the first one, agreement. That means a corresponding offer and acceptance.
Exactly. But remember, you also need consideration. That's the mutual exchange of value, something given by each side, and, crucially, intention to create legal relations.
Meaning the parties actually meant for their agreement to be legally enforceable, not just like a social promise.
Precisely. These are cumulative requirements. You need all three: agreement, consideration, intention, for a valid, simple contract. It's not enough just to have two.
It's interesting, though, how sometimes courts look at a situation that looks like a contract and might, sort of work backward to find these elements.
That can happen, yes. It's not always a perfectly linear, step-by-step judicial analysis. But the traditional way, the starting point for analysis is here.
With the offer and acceptance.
Exactly. The classic approach, the one you'll apply in most problems, begins with identifying a clear offer made by one party.
Which is then unconditionally accepted by the other.
Spot on.
And before we really dissect offer and acceptance, it's probably helpful to quickly touch on the two main types of contracts, because the rules play out a little differently.
Good point. Bilateral and unilateral contracts.
Most contracts are bilateral, right?
The vast majority, yes. It's an exchange of promises. I promise to sell you my laptop. You promise to pay me £800.
Neither of us has actually done anything yet, but we've swapped promises.
And that's the agreement. Both parties have future obligations.
A unilateral contract is different, though. That's an exchange of a promise for an act.
Yes. The offerer makes a promise to pay or do something if the other party performs a specific action. The classic example is offering a reward for finding a lost pet.
I promise to pay £500 to anyone who finds and returns my dog.
Exactly. And crucially, in that lost dog example, the offerer is the only one under an obligation, well, initially.
They've promised to pay if the dog is returned.
Right. No one is obliged to go look for the dog. But if someone does perform the requested act, finds and returns the dog, then the offerer is legally bound to pay the £500.
And you mentioned the rules are sometimes adapted for these unilateral situations.
They have to be, particularly around things like communication of acceptance and revocation. We'll get into that.
Okay, so the fundamental building block is finding that agreement. And it's built from an offer followed by a corresponding acceptance. Let's dive into the first part. What is a valid legal offer?
Right. So a contractual offer, it isn't just, chatting about maybe doing a deal.
It's more formal than that.
It's a statement, an expression of willingness to contract on specific, certain terms, made with the absolute intention to be legally bound as soon as the other party accepts it.
So no more negotiation needed. It's ready to go, just needs a yes.
Precisely. That's the test.
Okay, but how do we figure out if someone intended to be bound? We can't read minds.
No, thankfully. English law uses the objective theory of agreement. We don't try to figure out what someone subjectively intended in their head.
We look at what they said and did.
Exactly. What would a reasonable person infer from their words and their conduct? What do they actually communicate to the other party? That's what matters.
Ah, so it's about outward appearance, the communication itself, rather than secret thoughts. That makes sense. It gives certainty.
It does. You can rely on what someone said and did. This principle goes way back. Cases like Smith v. Hughes in 1871 about selling oats.
Oh, yeah, the old oats versus new oats case.
That's the one. Was there objective agreement even if the buyer subjectively thought they were getting something else? More recently, the Supreme Court case RTS Flexible Systems Ltd v. Molkeraya Lewis Muller in 2010. Lord Clark reiterated this. He said the court looks at what was communicated, words or conduct, and whether that objectively leads to the conclusion they'd agreed on all the essential terms.
So you look at the whole picture, objectively.
Yes. Consider Centrovincial Estates v. Merchant Investors Assurance Co. from 1983. A landlord offered a new rent, mistakenly typing £65,000 a year instead of £126,000.
Ouch. Big mistake.
Huge. The tenant immediately accepted the £65,000 offer. The landlord argued, come on, they must have known it was a mistake. No reasonable tenant would expect such a low rent.
But what did the court say?
The Court of Appeal found it was at least arguable that, applying the objective test, the offer simply was £65,000. The communication was clear.
So even with a mistake, if the offer looks clear and unambiguous on its face, the other party can often rely on it.
That's the starting point, yes. And in a business-to-business context, B2B, cases like Donani v. Kresniansky in 2011, confirmed that the objective interpretation is based on how a hypothetical, reasonable businessman in the offeree's position would understand it.
Okay, objective test is king. But is there any room for subjective knowledge? What if the offeree knows the offerer made a mistake?
Now you're getting to the exception, the snapping up doctrine.
Snapping up.
Yes. An offeree cannot snap up an offer meaning, accept it if they subjectively know that the offer is mistaken as to the terms of the offer itself.
So they can't deliberately take advantage of an obvious typo in the price, for example.
Exactly. The principal case here is Hartog v. Collins and Shields from 1939. Sellers mistakenly offered hareskins at a price per pound when they meant, and the trade custom was price per piece.
A big difference in price, presumably?
Massive. The buyer knew this was a mistake about the terms. The price per pound was way too low. The court said, nope, you can't snap up that offer.
So just to be really clear, it's knowing the offer is mistaken about the terms, not just knowing they're maybe a bit careless or made some mistake somewhere.
Precisely. Statoil ASA v. Louis Dreyfus Energy Services LP, that's the Harriet N case from 2008, clarified this. The offeree must know the offer is mistaken as to the terms being proposed, not just that they've messed up somehow.
And does the offeree have to definitely know, or is it enough if they, should have known?
The doctrine extends to where the offeree should have known. Perhaps because they were careless themselves, or maybe they even induced the mistake, or the context was just really weird.
Okay.
Think of Scriven Bros v. Hindley from 1913. Two different goods, hemp and tow, were accidentally given the same shipping mark. Very misleading. The buyer bid on one, thinking it was the other.
So they were mistaken about what they were buying.
Yes, and the court said, given the seller's carelessness in marking, the buyer should have realized something was up. So they couldn't claim a contract for the goods they thought they were buying. No snapping up.
Okay, so objective appearance is the rule. But if the offeree knows, or should know, the offer is mistaken about the terms, they can't accept. That adds a layer of fairness.
It balances certainty with preventing obvious exploitation.
Sure.
Right now, moving on from what is an offer, let's look at things that aren't offers. This is crucial.
Like just stating an intention or giving information?
Exactly. A statement of intention is merely saying what you plan or intend to do, not a firm commitment right now. The case Harris v. Nickerson from 1873 is a good example.
The auctioneer one.
That's it. An auctioneer advertised that certain items would be in an auction. This is just a statement of his intention to sell, not an offer to sell to anyone who turned up. Someone traveled specially for those items.
And couldn't sue and they were withdrawn. Right.
And supplying information. That's just providing facts without intending them to be acted on as a binding commitment. Harvey v. Facey in 1893.
Bumper haul pen.
The very one.
Yeah.
Will you sell us bumper haul pen? Telegraph, lowest cash price? The reply. Lowest cash price for bumper haul pen, £900. The court said that second telegram was just supplying information about the price, not offering to sell at that price.
So the first telegram was a request for info. The second was the answer. No offer yet.
Precisely. An offer has that clear commitment, ready for immediate acceptance. These other things are just stages, maybe, in negotiations.
Which brings us to the invitation to treat. That term always sounded a bit strange to me.
It is a bit archaic, isn't it? Think of it as an invitation to do business, an invitation to make your offer or to start negotiations.
So the person making the invitation isn't ready to be bound yet. They're inviting others to make proposals to them.
That's the idea. Like saying, here's some things I might be willing to sell. Why don't you make me an offer?
Okay, that makes more sense. And the law has specific categories that are usually invitations to treat, or ITTs.
Yes. The first classic example is the display of goods in a shop or shop window.
That still feels weird. Isn't the price tag an offer?
Logically, you'd think so. But generally, no. The display is an ITT. The customer makes the offer when they take the goods to the cashier.
And the shop accepts or rejects at the till.
Exactly. The key cases are Pharmaceutical Society v. Boots from 1953. That was about self-service pharmacies. And Fisher v. Bell in 1961, concerning displaying a flick knife in a window.
What was the reasoning in Boots again?
Well, the court said if the display was the offer, then the customer would accept just by putting the item in their basket.
Meaning they couldn't change their mind.
Right, or swap it for something else before paying. And the shop couldn't refuse to sell, even if it was, say, a medicine needing supervision. The ITT approach makes more commercial sense. The contract is formed at the till.
Okay, that logic holds up.
Yeah.
But you mentioned vending machines are different?
Yes, automated machines, vending machines, ticket machines at car parks are generally treated as making an offer.
Why the difference?
Because once you've put your money in or committed to the transaction, like getting a ticket at a barrier in Thornton v. Shoe Lane parking,
The car park case.
you usually can't change your mind or negotiate. The machine is essentially ready to be bound as soon as you perform the required action. It's automatic.
That distinction makes perfect sense. Okay, what about advertisements? Newspapers, leaflets?
Generally, also treated as ITTs, especially when they're advertising goods for sale where a bilateral contract is expected. Think Partridge v. Crittenden in 1968.
The Bramblefinch cocks, Bramblefinch hens, 25 shillings each ad.
That's the one. If that ad was an offer, the advertiser might be contractually bound to sell more birds than they actually had to, potentially thousands of readers. The court said no, it's just an invitation to treat. It invites readers to make offers to buy the birds.
But this is where the famous Carlyle v. Carbolic Smoke Ball Company comes in, right? That was an advertisement that was held to be an offer.
Absolutely. Carlyle v. Carbolic Smokeball from 1893 is the absolute landmark case for unilateral offers and ads. The ad promised £100 to anyone who used their smokeball as directed and still got the flu.
And they even said they deposited £1,000 in a bank to show they were serious.
Exactly. That deposit was key. The court said this wasn't just puffery or an invitation to treat. It was an offer for a unilateral contract.
A promise, a £100 reward in exchange for an act, using the ball and getting ill.
Precisely. The deposit showed a clear intention to be bound. It was an offer to the world, accepted by anyone who performed the conditions.
So the crucial difference is often the type of contract anticipated. Bilateral sale, probably an ITT like Partridge, unilateral reward for an action, potentially an offer, especially with evidence of serious intent like in Carlyle.
You got it. And while contract law makes that distinction, it's worth just mentioning consumer protection law, like the unfair trading regulations. These prohibit misleading ads, regardless of whether they're a technical offer.
So even if an ad is an ITT in contract law, a shop can still get in trouble under consumer law if they mislead people.
Yes, potentially. Cases like Trendos Filippo reinforce that retailers shouldn't refuse to sell advertised products if they have stock. But that's a separate regulatory issue from contract formation.
Okay, got it. So applying this, a grocery leaflet advertising oranges at 9p a kilo, that's almost certainly an ITT, following Partridge and Boots. It invites you to the shop to offer to buy the oranges.
While stocks last, of course.
And Carlo was different promise for an action, clear intent shown by the bank deposit, unilateral offer.
Exactly the right analysis. Okay, what about requests for tenders? When a company asks others to submit bids for a project.
That sounds like an invitation for others to make offers, so an ITT.
Generally, yes. The party asking for tenders is inviting suppliers to make offers, the tenders. Harvella Investments Ltd v. Royal Trust Co. of Canada supports this.
But there's an exception. I seem to remember something.
Yes, the important one from Blackpool and filed Aero Club Ltd v. Blackpool Borough Council in 1990.
What happened there?
The court found that sometimes the party requesting tenders might make a separate implied offer to consider all conforming tenders submitted correctly.
So not an offer to accept a tender, but an offer about the process.
Exactly. If they then fail to consider a valid tender, they could be in breach of that implied collateral contract about the tendering process itself.
That's quite subtle. Okay, how about auctions?
In a typical auction, the auctioneer asking for bids is the ITT. Each bid is an offer.
And the hammerfall is the acceptance.
Correct.
But what about auctions advertised without reserve?
The special case. If it's without reserve, The auctioneer makes a separate, collateral, unilateral offer
What's the offer?
to accept the highest genuine bid, whatever it might be. This offer is accepted by the person who makes that highest bid. Cases like Wardlow v. Harrison and Barry v. Davies confirm this.
So the auctioneer is then contractually bound by that collateral contract to sell to the highest bidder.
Yes. If they refuse, the highest bidder can sue them for breach of that collateral contract, usually for the difference between their bid and the market value.
Okay, so even within auctions, the ITT rule has a key exception. Let's apply this to that TV price mistake example. A website listing TVs at, say, £2.99 instead of $299.
Right. Well, displaying goods on a website, it's generally treated like a shop window display.
So an invitation to treat.
Usually, yes. The customer clicking Add to Basket or Buy Now is typically the customer making an offer to buy. The contract is usually formed later, maybe when the retailer processes the order or sends a dispatch confirmation.
But the price, £2.99 for a TV, that's obviously wrong.
Exactly. This brings us right back to the snapping up doctrine we talked about earlier.
Hartog v. Collins and Shields.
Precisely. A reasonable person, let alone a reasonable consumer, would know £2.99 is a mistake for a TV. They know, or should know, the retailer is mistaken as to the terms, specifically the price.
So they can't snap up that offer.
No. Applying Hartog and maybe Scrippen Bros, they wouldn't be able to enforce a contract at that price. The retailer could refuse the order without being in breach because no valid contract at £2.99 ever existed.
That makes total sense. Prevents unfair advantage from typos. Okay, let's quickly recap the offer section. An offer, clear expression, willingness to be bound on specific terms, judged objectively. Distinct from ITTs, shop displays, ads, tenders, statements of intention, or just giving info. Key ITT examples: Boots, Fisher v. Bell, Partridge. Key exceptions, nuances: unilateral offers, Carlyle, without reserve auctions, Barry v. Davies, and the snapping up doctrine for known mistakes, Hartog. You must establish a valid offer first.
Absolutely. And as you think about this, ask yourself, what's the real difference between an offer and just testing the waters? Why are ads usually ITTs? How do machines fit in? These distinctions are vital.
Okay, we've nailed down what an offer is and isn't. The next crucial step for agreement is acceptance. So, what exactly does the law mean by acceptance?
Acceptance is the unqualified agreement to all the terms of the offer. It has to be a mirror image of the offer.
Mirror image, so it has to reflect the offer back exactly.
Perfectly. No changes, no additions, no new conditions. If the offer is, I'll sell you my bike for £200, saying, okay, £200, but you have to throw in the helmet, is not acceptance.
Because it added a new term.
Exactly. That's not unqualified agreement. And just saying thanks for the offer, well, that's not acceptance either. Cases like Arcadis Consulting v. Angie confirm that. Acceptance needs to show clear assent to the terms.
And like the offer, acceptance is also judged objectively.
Yes, it is. We look at the offeree's words or conduct. What would a reasonable person infer? Do their actions or words objectively show they're agreeing to the offer's terms?
So acceptance doesn't always have to be a formal "I accept." It can be through action.
Absolutely. Acceptance by conduct is very common. A great example is Brogdon v. Metropolitan Railway Company from way back in 1877.
What happened there?
They'd been dealing for years without a formal contract. They drafted one, but it never got properly signed by both sides. However, crucially, they continued their business dealings on the terms set out in that draft agreement.
So they acted as if the contract was in place.
Precisely. The court held their conduct carrying on business, according to the draft, objectively amounted to acceptance of those terms. Their actions spoke louder than the lack of a signature.
Makes sense.
Similarly, more recently, Claxton Engineering Services v. TXM Olage in 2010. A Hungarian company kept trading with an English company even after saying they rejected a specific dispute resolution clause.
But they kept trading.
Yes. The court found that by continuing to accept goods and services, they had objectively accepted the English company's terms, including that clause, despite their earlier words. Conduct won out.
That really shows the power of conduct. Okay, acceptance must mirror the offer. What happens if the offeree replies but tries to change some terms? You said that's not acceptance?
Correct. That is a counteroffer, and this is a crucial rule. A counteroffer is treated as a rejection of the original offer.
It kills the original offer, terminates it.
Yes, it cannot be accepted later. Once you make a counteroffer, you can't backtrack and say, oh, actually, I'll take your original offer.
Because it's gone.
It's gone. The classic illustration is Hyde v. Wrench from 1840. Defendant offered to sell a farm for £1,000. Claimant replied, offering £950.
That's the counteroffer.
Yes. The defendant refused the 950 pounds. The claimant then said, okay, fine, I'll pay the original 1,000 pounds. Too late. The court held the 950-pound counteroffer had destroyed the 1,000 pounds offer.
Yeah.
It was no longer available to be accepted. No contract. Remember, Hyde v. Wrench counteroffer kills the original offer.
Got it. Counteroffer rejection plus new offer. But what if the offeree just asks a question about the offer? Like, would you consider payment over installments? Is that a counteroffer?
That's different. Merely querying the terms or asking for clarification without intending to reject the original offer is just a request for information.
And that doesn't kill the original offer?
No, the original offer remains open for acceptance. The case for this is Stevenson, Jock & Co. v. McLean from 1880. An offer was made to sell iron. The offeree telegraphed asking if the seller would accept delivery over 2 months or state their longest limit.
Just asking for flexibility.
Yes. The court held this was a request for information, not a counteroffer, so the original offer could still be accepted afterwards, which it was.
So you really have to look closely at the language. Is it proposing new terms, Hyde v. Wrench counteroffer, or just seeking to understand the existing terms better? Stevenson v. McLean request for info. That's a key distinction for problem questions.
Absolutely vital. And speaking of problem questions, the battle of the forms is a classic scenario.
Ah, yes, where two businesses exchange their own standard terms and conditions, and they conflict. Whose terms apply?
It can get messy, but the dominant rule in English law is the last shot rule.
Last shot.
Yes, firmly established by the majority in Butler Machine Tool v. Excello in 1979. The contract is generally concluded on the terms of the party who sent the last form in the exchange that wasn't explicitly objected to by the other party.
So whoever gets their terms in last, and the other side doesn't complain but just carries on.
Like taking delivery of goods, for instance.
Yeah.
The terms usually prevail. They fired the last shot that was accepted, often by conduct. Remember Butler Machine Tool?
I seem to recall Lord Denning wasn't keen on that approach in Butler.
No, he wasn't. He preferred looking at all the communications as a whole, finding substantial agreement, and maybe implying reasonable terms for any gaps. A more holistic view.
But that didn't catch on.
No, his approach was criticized for creating too much uncertainty in commercial deals. Later courts have firmly reasserted the traditional last shot approach for the sake of certainty. Tech Data Interconnections, Ltd v. Amphenol Ltd. in 2009 confirmed this. Remember, Tech Data.
So, for Battle of the Forms, track the sequence, identify the last set of terms sent that wasn't rejected, and that's probably the winner.
That's the general rule, yes.
And if this whole offer acceptance counter-offer analysis means no contract is actually formed, what then?
Well, there's no contractual remedy. But if one party has already provided goods or services, the law of restitution might step in.
To prevent unjust enrichment.
Exactly. They might have to pay a reasonable sum for the benefit they received. BSC v. Cleveland Steel in 1984 is an example where restitution was considered because no formal contract had been finalized despite work being done.
And you mentioned earlier that sometimes this whole offer acceptance framework just doesn't quite fit.
Yes, in some complex multi-party situations, like the Eurymnian case involving shipping and stevedores, Lord Wilberforce acknowledged the technicalities, but said the law takes a practical approach.
Yeah.
And in very specific contexts, like the relationship between a Methodist minister and the church, president of the Methodist Conference v. Preston, the Supreme Court decided it just wasn't a contractual relationship amenable to this analysis.
But for most standard agreements, the offer acceptance model is the way to go.
Yes. For standard commercial or everyday deals, it's the framework we use.
Okay, let's apply this. Party A offers cement. Party B asks about the quality. That's a request for info, Stevenson v. McLean. Offer still open. Then B faxes, accept your price for premium quality cement, assuming it is premium quality.
That looks like a clear, unqualified acceptance. Mirror image, contract formed.
But if B had said, I'll buy it if you drop the price by 5 pounds a ton.
Counteroffer. Hyde v. Wrench. Kills A's original offer. No contract unless A accepts the new price.
And the battle of forms. Forms go back and forth. Seller sends the last form with their terms. Buyer doesn't object, maybe sends a purchase order referencing it, accepts delivery. Contract is likely on the seller's terms. Butler, Tech Data. If seller then fails to deliver,
They're potentially in breach based on their own terms that formed the contract via the last shot rule.
right. So acceptance recap, mirror image, unqualified agreement, objectively assessed, can be by conduct, Brogdon. Crucially distinguish counteroffers, Hyde v. Wrench, from requests for information, Stevenson v. McLean, and handle battles of the forms using the last shot rule, Butler Tech Data.
Exactly. So we have an offer and we have acceptance. The next piece is communication, section 2.4, communication of acceptance.
This seems pretty obvious. You have to tell the offerer you accept, right? They need to know.
That's the general rule, yes. Acceptance isn't effective until it is actually communicated to and received by the offerer. It has to be brought to their attention. No meeting of minds if one mind doesn't know the other has agreed.
Can silence ever count as acceptance? What if someone says, if I don't hear from you by Friday, I'll assume you agree. Can they do that?
Generally, absolutely not. The law is very clear. Acceptance cannot be inferred from silence just because the offerer says so. The offerer cannot impose a contract on an unwilling offeree by saying silence equals acceptance.
Is there a key case for that?
The classic case is Feldhaus v. Bindley from 1862. An uncle offered to buy his nephew's horse. He wrote, "If I hear no more about him, I consider the horse mine." The nephew intended to sell to the uncle, told an auctioneer not to sell the horse, but crucially never communicated his acceptance back to the uncle.
And the court said,
No contract. The nephew's silence did not amount to acceptance, even though he mentally intended to accept. Remember, Feldhaus v. Bindley.
what's the policy reason to stop people being forced into contracts they didn't actively agree to?
Exactly. It protects the offeree from unwanted obligations being foisted upon them. Now, the rule isn't completely absolute. Silence might constitute acceptance in very limited circumstances where it doesn't involve forcing a contract on an unwilling party.
Like what?
Perhaps where the offeree themselves suggests silence as the method, or where previous dealings between the parties make it reasonable to infer acceptance from silence. The court in Rust v. Abbey Life mentioned this possibility, obiter. But the general principle from Feldhaus v. Bindley is strong. The offerer cannot impose acceptance through silence.
Okay. What about modern communications? Emails, faxes. If I email an acceptance to an office server at midnight on Saturday, when is considered communicated? When it arrives or when they open it Monday morning?
That's a really important practical question. Courts have drawn an analogy from cases dealing with notices sent electronically, like Tenax Steamship Covey owners of the motor vessel Brimneys, which is usually just called the Brimneys. That was from 1975.
And what did the Brimneys suggest?
It involved a notice of withdrawal of a ship sent by telex during office hours, but only read the next day. The suggestion is that communication to an unmanned receptor, like an email server or fax machine, is effective not necessarily the instant it arrives, but when it's reasonable to expect the machine to be checked.
So for that midnight Saturday email?
It's likely only effectively communicated at the start of the next business day, say 9 a.m. Monday, when staff would reasonably check emails. Remember the Brimneys for that principle.
That makes practical sense. You can't assume 24/7 monitoring unless it's agreed. Okay, thinking about our orange example. Someone offers to buy oranges. You don't explicitly reply, but you just deliver a kilo of oranges to their house. Is that acceptance? Is it communicated?
Yes, that would likely fall under acceptance by conduct, like we saw in Brogdon. Delivering the oranges is an action objectively showing you accept their offer to buy.
And the deliver itself communicates the acceptance.
Exactly. The physical act of delivery brings the acceptance to the offerer's attention. So a contract would likely be formed there by conduct and communication through that conduct.
It's interesting how these rules interact. And thinking about Feldhaus v. Bindley again, the nephew arguably suffered a detriment by not selling the horse elsewhere, right? But the rule protected him from being bound by silence. Can the offerer use Feldhaus to get out of a deal?
Only if the offeree is trying to claim their own silence counts as acceptance against the offerer's wishes. The rule primarily stops the offerer imposing silence on the offeree.
Got it. So communication of acceptance generally required. We prefer the receipt rule for instantaneous methods like email, fax, time to when receipt is reasonably expected, the Brimneys. Silence is not acceptance, Feldhaus v. Bindley, with very limited exceptions.
That's the core. But of course, there are exceptions to the need for communication. Section 2.5 covers these.
Right, where acceptance is effective even if not actually communicated back to the offerer.
Yes. The first is straightforward. The offerer can expressly or impliedly waive the need for communication.
Like in Carlil v. Carbolic Smokeball Co.
Exactly the case. The Carbolic Smokeball Company, by the nature of their public offer, waived the need for people to notify them before starting to use the smoke ball. They implied that performing the act was sufficient acceptance, no need to write back first.
Which leads straight into the second, very related exception, unilateral offers themselves.
Right. For unilateral contracts, acceptance is typically completed by the full performance of the act requested in the offer. You don't need to communicate your intention to perform beforehand.
Carlo, again, acceptance was using the ball and getting the flu, not sending a letter saying, I'm starting now.
Precisely. The rationale is that for offers made widely to the public, like rewards, it would be completely impractical and unreasonable to expect everyone who starts trying to fulfill the condition to notify the offerer. Performance is the acceptance.
Okay, that makes sense. And the third exception, the big one.
The postal acceptance rule. This is a specific and somewhat controversial exception just for acceptances sent by post.
Developed because the post used to be slow and unreliable.
Exactly. Back in the early 19th century, there were significant delays and risks of letters getting lost. If acceptance was only effective when the letter arrived, the offeree who posted it would be left in limbo, not knowing if a contract was formed or not.
So the rule shifts that risk. How?
Where the postal rule applies, acceptance is complete and legally effective the moment the letter is properly addressed and put into the official post box. Not when it's delivered, not when it's read. The moment it's posted.
Even if it gets lost and never arrives?
Even if it gets lost and never arrives, the contract is formed on posting. The key foundational cases are Adams v. Linsell from 1818 about wool and household fire, and Carriage Accident Insurance Co. Ltd. v. Grant from 1879 about shares. Remember Adams v. Linsell and Household Fire v. Grant? These cases put the risk of delay or loss squarely onto the offerer.
But surely this rule doesn't apply every time someone posts something.
No, definitely not. There are important limitations. First, using the post for acceptance must have been reasonably contemplated by the parties. This might be because the offer was made by post, or it's just a normal, reasonable way to reply in the circumstances. Household Fire v. Grant, Henthorne v. Fraser.
And it only applies if the letter is addressed correctly.
Absolutely. It does not apply if the offeree messes up the address. The risk of the offeree's own mistake stays with them. L.J. Corbettis v. Transgrain Shipping.
And the practical difficulties. A contract can be formed without the offerer even knowing.
Yes, that's the main issue. The offerer could receive the posted acceptance days later, having already sold the goods to someone else in the meantime, thinking the offer hadn't been accepted. They'd unknowingly be in breach of the first contract formed by post.
It feels really counterintuitive compared to the general communication required rule.
It does, and modern courts are very reluctant to extend it. It's often called an anachronism in today's world of faster communication.
Is there a case showing that reluctance?
Yes. Howell Securities v. Hughes from 1974 is key. An offer required notice in writing to exercise an option. The offeree posted the notice, but it never arrived. The court held that the phrase notice in writing meant actual communication was required. The specific wording of the offer effectively excluded the postal rule. Remember Howell Securities.
So the offerer can word the offer carefully to avoid the postal rule applying.
Yes, they can stipulate that acceptance requires actual receipt.
And for instantaneous or near instantaneous methods, telex, fax, email, the postal rule is definitely out.
Definitely out. Courts have consistently refused to apply it. For telex, the landmark cases are Entors v. Miles Far East Corps in 1955 and Brinkabon Ltd. v. Stahag Stahl in 1982. Remember Entors and Brinkabon.
Why not apply it to them?
The reasoning was that these methods are much more like face-to-face or phone conversations. You generally know if the communication has failed. So the normal rule applies. Acceptance is effective when and where it is received.
And fax and email are treated the same way. Receipt rule.
Yes. While maybe not perfectly instantaneous, like telex was thought to be, the strong judicial preference is for the receipt rule. Cases like JSC's Estefoni treated fax as instantaneous. And while there's no definitive Supreme Court ruling on email acceptance yet, strong indicators point away from the postal rule.
Like what?
Well, there's obiter dicta in Thomas v. BPE Solicitors suggesting the postal rule shouldn't apply to email. Other jurisdictions like Singapore have confirmed the receipt rule, Tri Kin Keong v. Digiland Mall, and the electronic commerce regulations for online trading also point towards a receipt rule, talking about when communications are able to access.
So the current position, supported by recent cases like Athena Brands Ltd v. Super Drugstores involving email,
Repeat Athena Brands.
Is that the receipt rule is preferred for email and fax.
Yes, that's the clear friend and the most likely position. The postal rule is largely confined to non-instantaneous postal communication where it hasn't been excluded.
Okay, this raises that really tricky scenario. What happens if the postal rule does apply? So I post my acceptance letter, contract formed, but then I immediately regret it and phone the offerer or send an email rejecting the offer before my letter arrives. Which communication wins?
Ah, the classic exam favorite.
Yeah.
And a genuine point of uncertainty in English law. There is no binding English case directly deciding this.
So what do we rely on?
We have old cases from other jurisdictions, like the Scottish case Countess of Dunmore v. Alexander from 1830, which suggested the faster revocation could be effective, and a New Zealand case, Wenkheim v. Arndt. But these aren't binding on English courts and have limited persuasive authority. Remember, Countess of Dunmore.
So how should we approach it in an exam?
You need to acknowledge the uncertainty, explain the technical position under the postal rule, contract forms on posting, then explain the counter argument. If the offeror receives the faster rejection before the postal acceptance arrives, they haven't relied on the acceptance. They aren't prejudiced if the contract isn't formed.
So the faster communication should prevail.
That's the argument, often supported by academic writers like Treitel. It aligns with the modern reluctance to extend the postal rule, UoL, and a preference for actual communication, Ontour's Brinkebon. You discuss both sides and the lack of clear authority.
That's a perfect example of needing to show understanding of the debate, not just a rule. Okay, exceptions to communication rule recap. Waiver by offeror, Carlil. Unilateral offers where performance is acceptance, Carlil again. And the postal rule, Adams, household fire, which is limited, Hallwell, and doesn't apply to modern instantaneous methods where the receipt rule prevails. Ontour's, Brinkebon, Athena brands, plus that unresolved point about overtaking a postal acceptance.
Nicely summarized. Okay, next section, 2.6. Method of acceptance.
Yeah.
Does the offeree have free choice in how they communicate acceptance?
It seems logical the offerer could specify how they want to be told, like reply by email only.
Yes, they absolutely can stipulate a particular method of acceptance. Manchester Diocesan Council for Education v. Commercial and General Investments from 1970 confirms this. Remember Manchester Diocesan Council?
Can the required method be implied?
Yes. Sometimes it can be inferred. If someone makes an offer by a very quick method, like fax or maybe even email now, it might imply they expect a similarly quick response. A slow reply by post might not be valid in that context. Quinter Duane v. Cole touched on this.
Okay, so the offerer stipulates a method. Does the offeree have to use only that method? What if they use something else?
Good question. They don't have to use the stipulated method unless the offerer made it crystal clear that only that method would suffice. They have to use words indicating exclusivity.
And if they didn't make it exclusive, just suggested a method, like please reply by post.
Then the offeree can use an alternative method, provided that alternative method is no less advantageous to the offer than the one they stipulated.
No less advantageous. What does that mean in practice?
It usually means it's at least as quick and reliable in getting the acceptance to the offerer's attention. This principle also comes from Manchester Diocesan Council. If the alternative is just as effective, or even better, easier, faster, it's likely valid acceptance.
So if the offer says reply by post, but I send an email that arrives instantly, that email acceptance would probably be valid because it's faster, arguably more advantageous.
Exactly, unless the offerer had said reply only by post or something similar showing mandatory exclusivity.
Okay, so offer can stipulate method. If not exclusive, alternative methods are okay if equally or more advantageous. What about the other way around? Fax offer, accepted by letter, posted a few days later.
Well, a fax usually implies urgency. A letter is much slower. Accepting by letter, there is likely less advantageous to the offer than a prompt fax reply would have been. So unless the offer specifically allowed for slower methods, that letter acceptance might not be valid.
Got it. It's about meeting the offerer's implied needs, especially regarding speed.
Precisely. Okay, final section on forming the agreement, section 2.7. The end of an unaccepted offer. An offer doesn't last forever. Until it's accepted, there's no binding contract, so things can happen to bring the offer to an end.
The most obvious one is the offer changing their mind. Revocation.
Yes. An offer can be withdrawn or revoked by the offerer at any time before it has been accepted. That's the fundamental rule from Payne v. Cave way back in 1789. A bid at auction, which is an offer, could be withdrawn before the hammer fell acceptance.
What if the offerer promised to keep the offer open for a specific time? Say, this offer is open until Friday. Can they still revoke it on Wednesday?
Yes. Surprisingly, perhaps, they generally can. A simple promise to keep an offer open isn't legally binding unless the offeree has given something in return for that promise, what we call consideration.
Like paying a small amount to keep the option open.
Exactly. Without that separate option contract, the offerer's promise to keep the offer open is gratuitous, and they can revoke before the deadline, provided acceptance hasn't happened yet. Routledge v. Grant from 1828 established this. Remember Routledge v. Grant?
Of course, if the deadline passes without acceptance, the offer just expires anyway.
Yes, it lapses automatically at the end of the stated time.
And for a revocation to be effective, does it have to be communicated, like acceptance?
Absolutely essential. Revocation only takes effect when it is actually communicated to the offeree. Posting a letter of revocation isn't enough. It must reach the offeree.
Is there a case for that?
Yes, Byrne v. Van Tienhoven from 1880. An offer was posted from Cardiff to New York. The offerer then posted a letter revoking the offer. But before the revocation letter arrived in New York, the offeree had already telegraphed their acceptance of the original offer.
So, contract formed.
Yes, the acceptance happened before the revocation was communicated. The revocation was ineffective until received. Remember Byrne v. Van Tienhoven.
Does the communication of revocation have to come directly from the offerer, or can you hear it from someone else?
It doesn't have to come directly from the offerer. Communication through a reliable third party is sufficient. Dickinson v. Dodds in 1876 is the authority here.
What happened in Dickinson v. Dodds?
Dodds offered to sell property to Dickinson, promising to keep the offer open until Friday. On Thursday, Dickinson heard from a third party, someone reliable apparently, that Dodd had already agreed to sell the property to someone else.
So Dickinson knew Dodds had changed his mind.
Yes. Dickinson then tried to accept the original offer before the Friday deadline. The court held the offer had already been effectively revoked. Learning from a reliable source that the offer was no longer minded to sell was sufficient communication of revocation. Remember Dickinson v. Dodds.
Okay, that makes sense. Now, unilateral offers and revocation. This seemed tricky earlier. It feels really unfair if someone starts performing the act, like walking to York for a reward, and the offerer revokes halfway.
It does feel unfair, and generally, the law prevents this. The usual rule is that revocation of a unilateral offer is not possible once the offeree has started to perform the stipulated act.
What are the cases for that?
Arrington v. Arrington from 1952 is a key one. A father promised his son and daughter-in-law they could have the house if they paid off the mortgage installments. They started paying. The court held the father, or his estate after his death, couldn't revoke the offer once they'd embarked on performance. Salisbury v. Salisbury is another supporting case. Remember Arrington v. Arrington.
How does the law achieve that? Is there an implied promise not to revoke?
That's usually the reasoning. Courts often imply a collateral contract or an implied term within the main offer. The offerer implicitly promises not to revoke the main offer once the offeree begins performance. Starting performance is seen as acceptance of this implied promise not to revoke. Dahlia v. 4 Millbank nominees explained this structure. Remember Dahlia?
Giving it business efficacy, making the deal work fairly.
Exactly. However, there's a very rare controversial exception where revocation might be possible even after performance starts.
Which one is that?
Luxor Eastbourne, LPD v. Cooper from 1941. It involved an estate agent promised a large commission if they found a buyer for cinemas. The agent found a buyer, but the seller then refused to proceed with the sale, effectively revoking the offer of commission.
And the court allowed that.
Yes, the House of Lords held that, in that specific context, a large potential reward for potentially little work by the agent. There was no implied term preventing the owner from revoking by refusing to sell. Remember Luxor. But later cases like Schweppe v. Harper really emphasize how rare this Luxor exception is. The general rule remains. You usually can't revoke a unilateral offer once performance has begun.
Okay, so for activity 2.9, neighbor offers car for 10 pay, open till Monday. Saturday, puts note under door saying, forget it, can she revoke?
Yes. Promise to keep offer open isn't binding without consideration. Rutledge v. Grant. The note is communication of revocation. It's communicated before acceptance. Offer effectively withdrawn.
Right. What about revoking unilateral offers made to the world, like a reward posters put up everywhere? How on earth do you communicate revocation to everyone who might have seen it?
Logistically very difficult, maybe impossible, to ensure actual communication to everyone. English law doesn't have a definitive answer.
Is there any guidance?
The materials mention a U.S. case, Shuey v. USA from 1875. It suggested revocation of a public offer might be effective if it's given the same prominence and publicity as the original offer.
So advertise the revocation in the same newspaper, for example.
That's the idea. And interestingly, this might mean the revocation is affected even against someone who saw the original offer but didn't see the revocation notice. That would be an exception to the usual rule that revocation needs actual communication. But again, this is based on a U.S. case and isn't settled English law.
Okay, so that's revocation by the offer. How else can an offer end?
Rejection by the offeree. Simple enough, if the offeree says no thanks, the offer is terminated. And as we've already covered extensively,
A counteroffer acts as a rejection. Hyde v. Wrench again.
exactly, that kills the original offer. Activity 2.9 in analyzing Hyde v. Wrench really drills that home.
And we also talked about the offer posting acceptance, but then managing to communicate a rejection by a faster method before the letter arrives.
Yes, the unresolved point. Postal rule technically forms contract on posting, but strong arguments, Dunmore v. Alexander, Tritell's principle, non-prejudice, suggests the faster rejection might prevail if received before the offerer relies on the posted acceptance. Definitely something to discuss if it comes up.
An offer can also just die if a condition isn't met.
Yes. If the offer is subject to a condition, stated or implied, and that condition fails before acceptance, the offer terminates. Financing's LTD v. Stimson in 1962 is the classic example.
The car damaged before acceptance.
Right. Offer to purchase a car was made. Before the finance company accepted, the car was badly damaged. Court implied a condition that the car would remain in substantially the same condition. Condition failed, offer terminated. Remember, Financing's LTD v. Stimson.
What about death? If the offerer or offeree dies before acceptance?
This can terminate the offer, though the position isn't perfectly crystal clear from old cases. Bradburn v. Morgan versus Dickinson v. Dodds-Obiter. The best view seems to be an offeree cannot accept if they know the offerer has died. Acceptance might be possible in ignorance of death, maybe if the contract isn't personal. Death of the offeree almost certainly terminates the offer. It's usually personal to them.
And finally, the offerer just runs out of time.
Yes, lapse of time. If the offerer sets a specific time limit, offer open until 5 p.m. Friday, the offer automatically lapses then if not accepted. Offer v. Davies relates to this.
And if no time limit is set?
Then the offer lapses after a reasonable time. What's reasonable depends entirely on the circumstances of the subject matter. Shares need faster acceptance than land, trade customs, etc. Ramsgate Victoria Hotel v. Montefiore in 1866 is the key case.
What happened there?
An offer to buy shares made in June wasn't accepted until November. The court held the offer had lapsed due to the passage of an unreasonable time. 5 months was too long for shares. Remember Ramsgate Victoria Hotel?
Okay, quick summary of how an offer can end. Revocation by offerer, communicated. Byrne v. Van Tienhoven, Dickinson v. Dodds. Unilateral issues. Arrington, Dahlia, Luxor exception. Rejection by offeree includes counteroffer, Hyde v. Wrench. Failure of condition financings v. Stimson. Death, sometimes. Lapse of time, stated or reasonable. Ramsgate, Victoria Hotel.
Perfect. Okay, we've covered all the core principles. Now let's briefly talk about applying this knowledge, especially for exams. As the source material highlights, offer and acceptance rules are a very frequent source of exam problems.
Because they're detailed and there are lots of potential tripwires.
Exactly. They test your ability to define terms, distinguish concepts, apply rules, spot exceptions, and use case law accurately. The key skill is breaking down a problem scenario chronologically.
Looking at each communication in turn and deciding what it is and what effect it has.
Precisely. What does the first letter do? Is it an offer, store, or an ITT? Gibson. How does the reply change things? Is it acceptance, counteroffer, Hyde v. Wrench? Just a request for information. Stevenson v. McLean.
Let's quickly walk through sample question 1 again with that mindset. Alice offers shares to Bill, let me know by Saturday. Bill posts acceptance Thursday, changes mind, leaves phone message Friday, 6 p.m. Alice opens letter Monday, here's message Monday.
Okay. Chronologically, Alice's letter looks like an offer, store. Time limit? By Saturday, not binding unless option contract. Routledge v. Grant. Offer lapses Saturday if not accepted. Bill posts acceptance Thursday. Postal rule applies. Yes, post seems reasonable. Adams household fire. Contract formed on posting Thursday.
But then Bill leaves the phone message Friday evening trying to withdraw.
Attempted revocation of acceptance, but the contract technically exists since Thursday. Can you do that? This hits the Dunmore v. Alexander uncertainty.
The faster communication overtaking the slower one.
Right. Argue both ways. Technical postal rule says contract exists. Counter-argument. Alice gets rejection, phone message, and acceptance, effectively simultaneously on Monday morning. Phone message likely effective Monday morning when reasonable to check. The Brimness analogy. Alice isn't prejudiced by the postal rule if she knows of the rejection before acting on the letter. Modern preference for receipt rule, On Tours, Brinkabon, Athena Brands, supports revocation being effective.
So, most likely outcome is no contract, despite the technicality.
That's the likely conclusion you'd reach after discussing the competing arguments and lack of binding authority. Show the examiner you see the issue.
Question 2. Cyril asks Devi if interested in stamp collection, ITT. Devi replies, willing to pay £500, offer, adding, consider it mine unless I hear to contrary.
Devi makes an offer to buy. but then tries to impose silence as acceptance. Rule.
Feldhaus v. Bindley. Can't impose silence.
Correct. So, part A, Cyril sells to Eric without replying. Fine. No contract with Debbie. Her offer wasn't accepted.
Part B, Cyril puts stamps aside marked sold to Debbie but doesn't tell her.
Internal action. Acceptance generally requires communication. Unless communicated, no acceptance, no contract, Debbie isn't bound. A weak counter-argument might be Debbie waived communication, but Feldhaus is strong here.
Question 3. Jan 1A writes, considering selling. Wonder if you'd like. Expect £500 for horse.
Language like considering wonder, expect points strongly to ITT. Gibson, not a firm offer.
Jan 2 replies, I accept your offer.
And accept an ITT. B's reply is actually an offer to buy for £500.
Jan 3, A writes back, don't be ridiculous, want £750. Adds, do not write back unless you do not want the horse.
A rejects B's £500 offer, makes a counteroffer of £750, Hyde v. Wrench. This kills B's £500 offer. A then tries to impose silence as acceptance.
Invalid under Feldhaus v. Bindley.
Right, so if B tears up the letter without reading, no contract. Brood never accepted the £750 counteroffer.
But part B, what if B reads it, decides to buy for £750, but A then refuses?
Now B has accepted the £750 counteroffer. How? By silence, exactly as A proposed. Do not write back unless you do not want. This is the exception where silence can be acceptance because it was proposed by the offerer and relied upon by the offeree, not forced on an unwilling party. Rust v. Abbey Life Obiter. A contract for £750 exists. A is in breach for refusing to sell.
Wow, walking through those step by step, applying the cases chronologically really makes a difference. You see how each communication changes the legal position.
That's precisely the skill. Identify the communication, apply the rule in case law, determine its effect, then move to the next communication. Is it offer ITT? Acceptance counteroffer request for info. Postal rule. Revocation. Communication issues.
And you can see these principles everywhere once you look. Buying Tetral displays, ITT. Picking up pump, maybe offer. Paying acceptance. Bus timetables, ITT. Bus pulling up, offer. Getting on acceptance. Ticket machines, offer. Inserting money, acceptance.
Exactly. Applying the concepts to everyday scenarios helps them stick.
So we've taken a pretty deep dive into agreement today. From figuring out what an offer actually is, to the mirror image rule for acceptance, the vital communication rules, and those tricky exceptions like the postal rule, and all the ways an offer can die before it becomes a contract.
A solid grasp of offer and acceptance is absolutely foundational. It's the starting point for understanding how legal agreements come into being.
It definitely requires careful reading of the facts, knowing the rules, and crucially, knowing the key cases that set those rules. We really hope this deep dive has helped clarify these concepts for you and made you feel more confident in tackling problems.
Definitely revisit the cases we've mentioned, like Carlyle, Hyde v. Wrench, Feldhaus v. Bindley, Boots, Adams v. Lenzel, Ontours, Byrne v. Van Tienhoven, Dickinson v. Dodds, Arrington. The list goes on, but they each represent a key principle. Practice applying them.
And a final thought. While we have these detailed rules, contract law often involves balancing principles, certainty versus fairness, the objective view versus preventing exploitation. How might these principles continue to evolve, especially with things like smart contracts or AI negotiations?
That's a fascinating question for the future, isn't it? How do these 19th and 20th century rules adapt to 21st century technology? Something for you to ponder.
Indeed. The journey through contract law definitely continues. A massive thank you again to the University of London for providing the materials that made this deep dive possible.
And thank you to Sinorbit Academy Sri Lanka for sponsoring this educational session.
And to everyone listening, especially those studying for exams, we really do wish you the very best of luck.
Trust your preparation, stay calm, break those problems down logically, communication by communication, apply the rules step by step.
You can do it. Good luck.